Hi, I'm Ryan Eldred. I am an immigration attorney with the law firm Crimmigration Inc., and I want to talk to you a little bit about the Special Immigrant Juvenile Visa process. First off, who's it for? Children under the age of 21 who are in the United States and are undocumented and were either neglected or abandoned by one or both of their parents, as a general matter, are eligible for this visa type. It's a multi-step process that begins with a custody change. Now, a custody change can happen several different ways. Typically, it is something like a guardianship or a conservatorship. Potentially an adoption can be a custody change. But it can also be something like a juvenile delinquency order that places a child into foster care. That's also a custody change. Regardless of which method is used, ultimately you need an order from a judge saying that the child went into somebody's custody. Parentage doesn't have to be changed at all, just that they are now in the custody, physical and legal, of an individual or an organization. And as part of that custody change, the judge will also make something called Special Immigrant Juvenile Findings. Now, the first step is usually done with a county superior court. It's done usually in the probate department. The second step is a petition that's filed with U.S. Citizenship and Immigration Services. The form is Form I-360. You'll include with that evidence of the custody change order, as well as evidence of the child's birth, their age, their identity, and so on. The third step in the process is for children that are in removal proceedings or in deportation proceedings. If a child is indeed in deportation proceedings, they'll become eligible during this process to either temporarily close those proceedings and fully permanently terminate them later, or terminate them in the first instance. But that's usually done with the immigration court, the Executive Office for Immigration Review. Once that step is done, or if they're not in removal proceedings, that step isn't necessary. The final step in the process is awaiting visa currency and a filing for permanent residence. So the child will eventually become eligible for lawful permanent residence in the United States, also known as a green card. And that last step can only happen when a visa becomes available. Right now, special immigrant juvenile visas are available after about 5 years from the date that the petition was filed. So currently 5 years. So if a child who's 19 years old, for example, gets the custody change and a petition is filed for them, ultimately they'll be about 24 when they're able to get their residence.